Good afternoon, everyone. Welcome to another Wednesday webinar with the Property Law Alliance. It's actually our 20th episode this Wednesday, so it's quite exciting. We've made it. And then welcome Silna, Bruno, and Greg.
Hey.
Hi, good afternoon, guys.
How are you guys doing?
Not bad.
I refuse to answer. Because last week I was so excited and it was spring in my head. And now here we are and I look like an Eskimo. I was nice enough to take my beanie off for the recording. It's that cold. So I am bleak, but I'm all well, thank you.
I'm glad. I'm glad to hear that. All right, we don't have a lot of questions this afternoon, and we're pre-recording as a result of load shedding schedules. So, but we will host a watch party at 6. All right, the first one that we have is from Karen. She asked that a sectional title scheme allows owner of a share to enclose common property with exclusive rights and on other occasions to extend their units into loft conversions. No amendment of titles and scheme space allocation remains unchanged. Is this mismanagement of trustees and could this affect the fidelity license of the managing agent? The managing agent is an owner and trustee. So I think maybe Silna, if you can get us started on that one.
Is it because I'm bleak about the weather now you've decided, well, at least give me a question to entertain me. Thank you, Marilyn.
It's a pleasure.
So you can put your hat on between questions.
Yeah.
I will. So I think the answer it could be relatively easy, simply because this part of of sectional title schemes are heavily regulated by legislation. So the Sectional Title Schemes Management Act specifically deals with the use of common property, with the extension of your unit, things like that. So let's just start with a simple example. Say it's your exclusive use area. So I know the question deals with common property, but exclusive use area, if you want to extend, say for instance, close and make a loft. What I find interesting about the question is that she specifically refers to a loft. Now, I can't really see how your unit would be built in such a way that you can extend to build a loft, but then it will be on common property. That doesn't sound 100% right to me, but I suppose I've seen weird things. That sounds like exclusive use area. So to extend your exclusive use area, the rule is you need to get consent from the Surveyor General, and at the same time you also need to then get consent from the body corporate, and your conduct rules will deal with that. I'm sorry, I'm laughing. That was an unexpected move from my dad, but now everybody's met my dad. So that exclusive use area extension, there are very specific rules, and the body corporate can't willy-nilly consent to it. It must be dealt with in terms of the management rules. So if your management rules allow for that, if the correct process is followed and you get Surveyor General consent, then it is allowed. And in that particular situation, you would definitely then pay higher levies, because your participation quota, your PQ, will then increase, and you will then pay for that. Use on the common area, I must say, it sounds a little strange to turn common property into an exclusive use area completely. That sounds quite interesting. Bruno, help me out on that. I think you have an opinion on that.
So that's also why the question was a bit confusing. So the exclusive use areas, it's designed in order to give a specific owner use of an area that doesn't necessarily belong to him. So an extension to those areas, I can kind of understand because it's their areas anyway. But common areas, on the other hand, are completely different. This is meant to be shared. And everyone's got a right to use these areas. So sure, what I'd mentioned earlier is I've seen body corporates rent out specific common areas because let's say it was wasted space, so no one was really using it, and they actually rented these out to a business, for example, and allowed the business, one of the units, to actually extend and use it, but as with leasing rights, which was very different. So it wasn't something that was actually registered anywhere. It was almost the body corporate with all the trustees' consent entering into a lease agreement for a common area, based on the fact that, you know, no one had any objections to it. The owners didn't have any objections, anything of the sort. So I've seen that happen. And that is allowable. It is provided for in the Act.
Okay, thank you so much. Greg, do you maybe have something to add to that?
If it wasn't for Silna and Bruno, we'd be bereft. And thank goodness we have them and their cleverness, because no, I don't.
Sectional title is such an interesting thing, but Marilia, I think practically what this particular person can do, my advice would be to then either go to CSOS, their sectional title schemes ombud. That might be a bit of a problem right now. I know their offices are pretty much closed for practical purposes at this stage, but you can try. But the other option is obviously to go straight to the Estate Agency Affairs Board, because the managing agents must be registered there, and they will then take this into consideration, look into it, and then apply the necessary sanction. So if it was to the point where it was an unprofessional conduct, to the point that the person's FFC will be taken away, then they will do that. But this is definitely not something that you would just go to an AGM with and say, oh, this is a problem. You can potentially ask to call an SGM and vote this person off, or go to the EAAB with that. So that's just a practical what you do about it then.
Okay. Perfect. Thank you so much for that answer. And then the second question is regarding a property in an estate. So it's from Melody. She says, my mother-in-law passed away in May. The property was left to my husband and his sister. The lawyers are busy with the paperwork, but we have a problem with their dad. Their parents have been divorced for 20 years. He had nowhere to go, so he moved back in with the ex-wife. The property is on the mother's name. There is no lease agreement, and the father does not pay rent. They are having problems with him now. They want to evict him. Are they allowed to, and what is the process? All right, and maybe Greg, if you can get us started on that one.
Sure. One doesn't have to be occupying in terms of a lease. This sounds like what's called a precarium, which is essentially an authority to occupy, which can be terminated on reasonable notice. In this instance, the executor, I think, would be the operative individual, the person in charge for purposes of PI, who would have to give him notice to vacate. And once that time comes and goes, he can then be evicted. The worrying thing in the context of the information we have is the suggestion he had nowhere else to go, which often means he doesn't have the means to be somewhere else. And that may cause difficulty in due course with the city council being obliged to find temporary emergency accommodation for him, with the difficulty and a potential attendant delay that might happen. But absent that, it shouldn't be difficult. Absent that, one can terminate his right, his informal right of occupation. One can bring an eviction application if he doesn't vacate, and one can evict him. You know, we hope and trust he's not elderly. We hope and trust that he's not poor, because those two things may have the effect of delaying an outcome. But certainly he can be evicted. He has no right to live there against the wish, in the first instance, of the executor, and ultimately of the husband and his sister.
I know that Silna has a very similar case to this. And so from myself, so I agree 100% with Greg. The one thing people need to look out for is will fraud, because we're getting a lot of that nowadays. And it's just crazy. So I've got one now that's taking place where no one really understands how the property got to where it was. It was transferred by the estate, the person sold it, and now it's going all the way back to the children. And there's an argument that the children should have gotten a child share. Like another case that I also had a couple of months ago, there was outright will fraud, to the point where there were 2 wills and the signatures didn't match. And none of it actually made sense. And the relationship between the parties didn't make sense. And eventually you get embroiled in this family feud. So if you ever outside of this as a purchaser, we've said it before, I'm going to say it again, be very careful, because these family matters land up being a disaster. If there is will fraud, it falls back to interstate succession. And sometimes what you find is the spouse is entitled to a share, the children are entitled to shares, and then it makes division of the property a little bit more complex. So yeah, just be warned. So in this case, Greg is right. If there was a will and no one disputes the will, that's perfect. If somebody does dispute the will, it could land up being quite a dragged out affair.
Yes, exactly. I must say, again, look at me being practical this afternoon. Now, practical advice, practical advice on this would be, I would suggest, if the family members, well, I mean, you don't evict your mother's spouse or a parent or a family member while the relationship is amazingly awesome. I mean, it's unlikely that would be the situation. By the time you start evicting family members, the relationship probably already is pretty sour. So what I suggest is not to jump straight into eviction, but just to have an actual conversation, a recorded conversation, potentially with a relatively independent third party that can play a bit of middleman. And just so the issues, exactly what Bruno was referring to, with disputes around the will and things like that, just so you can air all of that and you can see what you're going to be dealing with. Because like Greg said, if it's a straightforward, simple will, and everybody knows that will was actually executed by the deceased, there shouldn't be a problem. But if it's already an issue, I would suggest that there's a bit of a mediation process just to see where the problem is, because the thing is, your problem is not the eviction. The eviction will take as long as any other eviction. The problem is the will. The problem is ownership, because the truth about an eviction is, and I can say it because I have Greg and Bruno here as well, an eviction is actually pretty simple. You just need to prove 2 things. You need to prove ownership and you need to prove illegal occupation. It's as simple as that. And if you already have a problem proving ownership, you're going to have a proper problem with an eviction. And I can see Bruno already raising a brow, because that's the first thing you need to prove. And if that is simple and sorted out, then the eviction should be simple. And I would like to see it aired and the actual common ground found before that time. And if you can see there's no way of solving that, litigate on the will and ownership before you commence the eviction. Only commence your eviction once you can prove ownership without too much effort. Otherwise, the eviction is going to be held up.
Except there doesn't appear to be a dispute as to ownership. There doesn't appear to be a suggestion. It's the long ex-husband who is obviously taken in because he's on his uppers. You know, the suggestion wasn't made that he's putting any kind of claim into the house. I'm much less what's the word, admiring of mediation than Silna is, because you don't want to give people ideas. Now, you don't want this guy to suddenly think, well, maybe I have a claim to the house. We were married 20 years ago. I did this, whatever the case may be. So while there's no suggestion, I would rather suggest that the executor give him formal notice now, unless it prompts an immediate cry of, but I'm a part owner, then the guy starts losing. And maybe before one institutes eviction proceedings, then go and have a word with him and say, okay, guy, what's your story?
Absolutely.
Are you going to go? Where are you going to go? Do we need to, well, not where we're going to, we don't care where you go, as long as you go. But make sure that there isn't any other story, because, yeah, certainly talking him out is going to be better than fighting him out.
Yes, I agree. It's interesting, Greg. I always weirdly believe that people
Me?
deep,
No.
deep inside are nice and will be reasonable, but you're right, they won't be. Okay, so ignore my advice.
No, don't ignore it
Cancel
at
and
all.
go.
Don't ignore it at all. You're completely correct. And even my black and crusty soul knows that overwhelmingly people are nice and respond accordingly. And that is the norm. And that's what society works on, that premise. But, you know, wills, hey? Your wills are, when someone dies and there's something afoot, an inheritance. I've seen it for years. Sane people go crazy. It's bizarre. So I must say, I think we both right to a degree. Trust no one, but give people the benefit of the doubt.
Oh, I like that.
And but what's actually also quite interesting, what Greg was saying is also the perception of lawyers and the type of work that we do. Like from an eviction perspective, it would always appear that we've got a certain mindset on how we approach people. And is it unkind? Are they, you know, is it ruthless? The reality is that even in a case like this, the person asking this question, you know, a lot of us would hear it with the assumption of, you know, she needs to get this person out. No, she needs to know whether she's entitled to get the person out, because when she approaches him and goes, listen, I really think you need to leave, she doesn't want to get into a little debate of yes, no, yes, no. It's a question of facts. Like, listen, you have to leave. Whatever we do from this point on to help you is a plus for you. So please understand, this is our rights, this is your obligations, but let's work together to find some kind of middle ground. If two people are on two completely different pages, and we've had this before so many times. Very similar cases also with evictions, where the one person felt that the bank shouldn't have sold their house and my client who bought the house wants the house. And they're in completely two different places insofar as negotiations, because our client wants them out and this person wants our client to wait until they fight with the bank and until that fight is over. If you're that far apart, like, negotiation isn't going to help. Knowing your rights makes it better to at least know where you stand with it and kind of clear the path to, you know, where you guys are going to move forward. So this might be the nicest person. It's just they need to know where they stand.
That's perfect.
Seconded.
No, I think that's quite clear. Well, that is the questions we have. I don't know if any one of you have something interesting to add or to discuss.
I'm mindful of the load shedding schedule, so yeah, it's probably better to say goodbye in a nice way than to just cut off.
Yeah.
That's exactly what I'm worried about, because I see we just moved from stage 2 to stage 4, so anything can happen. So I think I'm happy we got through all the questions with power. So it was a relatively short one.
Can I say one nice thing, which
Please.
is that we have conducted and executed our first post-lockdown eviction. So they're on, we are doing them, it's stuck, rock and roll.
Nice.
Brilliant. I'm glad you say that, Greg. We've had a few executions as well, and it's brilliant. I'm very happy. I'm very happy, and the orders are starting to be definitely better than in level 3. So evictions are definitely almost back to normal once you get in court. The dates are still a little delayed, and the municipal reports are still a bit of a nightmare. But I think we're rolling. Thanks for that.
I'm finding the court process is getting a little bit easier. So
we are as well.
So it's not as terrifying as it used to be. And even like the Zoom links and the appearances, maybe it's just luck, but over the last couple of ones we've gotten on, we've been on the roll, it's been good. Maybe it was us and we've just learned how to do it properly, or maybe the courts have actually I don't know, improve their systems. Either way, it does feel a little bit easier.
You know, let me acknowledge the South Gauteng High Court in any event. They've really been very good. The admin, I think it's catching up now. The court processes, the Zoom things, impeccable. I must say, if it wasn't for that, we understand that in Cape Town, everything's been kicked to the 4th term. They've just done nothing. So, you know, I mean, I'm very pleased that our Judge President, Judge Mlambo, set up this case lines thing, because it saved our bacon.
Yeah, I can't fault South Gauteng either. It's smooth and pretty awesome, and yeah, and North Gauteng as well.
And North Gauteng, they're a bit more nervous. They're a bit more COVID-y, but that's, I think, probably always the
COVID-y.
case.
Yeah.
I love that. Why is your eviction delayed? No, the court's been COVID-y.
COVID-y.
I love it, Greg.
Says it all, man.
It's like 2020 Oxford Word of the Year.
Yeah.
Yeah, feeling a bit COVID-y. You know. How's your day? 2020.
Yeah.
Right, thanks so much. Thanks
All
again,
right,
Murray.
Thanks so much, guys.
Take care, everyone.
Thank you, guys.
Cheers.
Bye-bye.
Bye.
Bye.